Get those trucks off my road, Richard, or I will have the county sheriff tow them. You have exactly 10 minutes before the heavy wreckers arrive. In commercial real estate, developers love to talk about vision. They stand on windy hillsides, point at fields of weeds, and talk about turning raw dirt into glass and steel monuments. They talk about job creation, economic growth, and shaping the local skyline. But if you spend 20 years in the dirt like I did, you learn that real estate is not about vision. It is about paper. It is about survey markers, utility easements, municipal sewer hookups, and county land registries. The prettiest architectural rendering in the world is nothing but expensive wallpaper if you do not own the right-of-way to run your heavy equipment onto the site. If you control the paper, you control the project. My name is Arthur Pendleton. For 8 years, I was the Director of Land Acquisition and Entitlements for Caldwell Development Group. I was the guy who did the dirty work that the executives in their custom-tailored suits did not want to touch. While they were drinking scotch at country clubs and shaking hands with city council members, I was sitting in windowless county archives reading 100-year-old deeds, negotiating with stubborn third-generation farmers, and arguing with municipal planners over stormwater runoff coefficients. Caldwell Development was run by Richard Caldwell. Richard was a man who measured his self-worth by the size of his office and the loudness of his voice. He was a second-generation developer who had inherited a solid mid-sized firm and convinced himself that he was a genius. His business model was simple: bid low, promise the moon, and squeeze every subcontractor, vendor, and employee until they squeaked. If a contractor made a mistake, Richard sued them. If an employee did a great job, Richard took the credit. By 2024, our biggest play was a project called the Ridgeview Commerce Center. We had under contract 180 acres of raw land in El Paso County, Colorado, just east of Interstate 25. The plan was to build a 3-phase, 1 million square foot logistics and warehousing hub. In the post-pandemic economy, warehousing space was gold, and we had a national shipping tenant lined up to lease the first phase before we even broke ground. The margins were tight, but the sheer volume of the project meant it would put Caldwell Development in the big leagues. But the Ridgeview site had a massive physical defect. The entire western boundary of the property, which faced the interstate, was blocked by a steep, unstable shale bluff and a protected creek corridor. Under environmental regulations, we could not cut a road through that creek without spending 3 years in permitting and millions of dollars in mitigation. The northern and southern boundaries were bordered by established residential developments whose homeowners associations would lobby the city council to block any commercial traffic. That left only one possible entrance: a narrow, 40-foot wide neck of flat land on the eastern edge that connected the property to a county road. Without that eastern bottleneck, the entire 180 acres was completely landlocked. When Richard first handed me the files for the Ridgeview acquisition, he told me to get the title commitment cleared in 30 days. I went to work. I pulled the tax maps, the historical deeds, and the survey records from the El Paso County Clerk and Recorder's office. I sat at a light table, comparing the legal descriptions of the parcels from the 1890s to the modern GIS database. That was when I found the anomaly. The main parcel we were buying was described in the contract as Parcel 400. But the 40-foot wide neck of land leading to the county road was designated on the old county maps as Parcel 402A. The title commitment from our national title insurance company had flagged Parcel 402A, noting that the chain of title was broken. They assumed it was a dedicated public right-of-way that had simply never been formalized by the county commissioners. But I do not assume. I drove down to the county courthouse and spent 3 days going through the physical archives, tracing the chain of title back to the late 19th century. I found the truth. In 1912, a defunct railway company called the Midland Terminal Railway had purchased that 40-foot strip to lay a spur line to a nearby coal mine. The railway line was abandoned in 1974, and the company dissolved shortly after. But the title to that strip of land was never transferred to the county, nor was it absorbed by the adjacent farm that we were purchasing. It was still owned by the ghost of the dissolved railway company, under Colorado law, because the railway company had been dissolved. For over 40 years, the property was essentially in legal limbo. I did not tell Richard. I knew how he operated. If I told him, he would have told me to find a way to quiet the title in the company's name, and he would have taken the credit. Instead, I spent $4,500 of my own savings to hire a specialized probate attorney. We located the last surviving trustee of the dissolved railway company's assets, an 84-year-old retired clerk living in Arizona. For $3,000 and a bottle of good whiskey, he signed a quitclaim deed transferring all rights of the railway company's residual land holdings in El Paso County to a newly formed entity I had registered. Vanguard Land Holdings, LLC. I recorded the deed. For $4,500, I now owned the only 40-foot wide entrance to a $65 million development site. To keep the project moving, I had Vanguard Land Holdings, LLC, execute a temporary access license to Caldwell Development Group. The license was simple. It allowed Caldwell, its employees, and its subcontractors to cross Parcel 402A for the purpose of site investigation, engineering surveys, and eventual construction. But I drafted the agreement myself, using a standard corporate template. I inserted one specific clause in the fine print, Section 14C. The clause stated that this license was a personal, revocable license granted specifically in consideration of the active employment of Arthur Pendleton as the Director of Land Acquisition for the licensee. Should Arthur Pendleton's employment with Caldwell Development Group be terminated for any reason by either party, the license would automatically expire 72 hours after the date of termination, without the need for further notice, and all rights of access would revert solely to the licensor. I presented the access agreement to Richard among a stack of 50 other documents during our final push for bank financing. He did not even read it. He just saw that the title company was satisfied with the access easement, signed the page, and threw it back at me. "Good job, Arthur," he said, not even looking up from his iPad. "Now get the zoning board to approve the variance for the loading docks. We break ground in 3 months." For the next 90 days, I worked 80-hour weeks. I got the zoning variance approved. I coordinated with the civil engineers to design the utility alignments down my 40-foot strip, and I secured the final grading permits from the county. The general contractor, a massive firm called Milestone Construction, was scheduled to mobilize their heavy equipment and begin the first major concrete pour for the warehouse foundation on Monday, July 13th. My contract with Caldwell Development Group was clear. For every major acquisition I brought to fruition, I was entitled to a 1.5% development fee upon the closing of the construction loan. The loan closed on July 8th. My commission was exactly $975,000. On Friday, July 10th, 3 days before construction was set to begin, Richard's assistant sent me a calendar invite for a 4 o'clock meeting in the executive boardroom. I thought we were going to sign the commission check and toast to the start of the project. Instead, when I walked into the boardroom, Richard was sitting at the long mahogany table. Next to him was his 29-year-old son, Ryan, who had spent the last 2 years running a small residential remodeling company into the ground, and a woman from HR named Brenda, whom I had never liked. There was no champagne on the table, only a manila folder. "Have a seat, Arthur," Richard said, gesturing to the leather chair opposite him. He did not look me in the eye. Instead, he was adjusting the cuffs of his white dress shirt, his gold Rolex catching the light of the late afternoon sun streaming through the boardroom window. I sat down. Brenda, the HR director, gave me a tight, professional smile that looked like it had been painted on her face. Ryan was sitting to her right, leaning back, tapping his thumbs on the screen of his iPhone. He was wearing a navy Patagonia fleece vest over a crisp button-down shirt, the uniform of every rich kid who had never swung a hammer but wanted everyone to think he was a builder. "We have a bit of a situation, Arthur," Richard began, clearing his throat. "The Ridgeview project is moving into the active construction phase on Monday. But as we completed the underwriting for the construction draw, our lenders flagged some concerns. The interest rates are climbing, and our steel fabrication costs are up 12%. To keep the bank happy, we have to find some immediate overhead reductions." I kept my hands flat on the table. "And what does that have to do with me, Richard? The loan closed on Wednesday. My acquisition work is complete." Richard sighed, a theatrical sound designed to show how heavy the crown was. "It means we are restructuring the development team. The acquisition phase is over. We do not need a full-time director of land acquisition on the payroll anymore. Ryan is going to take over as the lead developer for the construction and leasing phases. We are going to have to let you go, effective immediately." I looked at Ryan. He did not look up from his phone, but a smug little grin crept onto the corner of his mouth. I see, I said slowly. And my commission? The 1.5% acquisition fee on the closing of the $65 million construction loan. That is $975,000. Richard pulled a document from the Manila folder. It was a copy of my employment contract. He had highlighted a paragraph near the bottom of page 4. Section 8.2, Richard said, tapping the paper with his index finger. The acquisition fee is contingent upon the project meeting all initial scheduling benchmarks. Your zoning variance for the western loading docks was approved 3 weeks later than the timeline we submitted to the lenders last fall. Because of that delay, the performance metrics were not met. Technically, the firm is not obligated to pay the acquisition commission. I knew that clause. It was a boilerplate line that Richard inserted into every manager's contract, a loophole he used to shave off bonuses whenever he could. In court, I could have fought it and probably won, but it would have taken 3 years of litigation, $50,000 in legal fees, and by the time the judge ruled, Richard would have moved the project assets into another LLC and declared bankruptcy. You're quizzing me on a 3-week zoning delay, I asked, keeping my voice quiet and level. I spent 18 months in public hearings for you. I redrafted the utility plans myself to save the project $80,000 in civil engineering fees. The bank closed the loan. The money is in the construction escrow account right now. Business is business, Arthur, Richard said, pushing a second document across the table. We want to be fair. We are offering you a severance package. 3 weeks of salary plus a discretionary bonus of $25,000. In exchange, you just need to sign this standard release of claims. It is our standard exit package. Brenda handed me a pen. I took the document and read it line by line. It was a comprehensive, ironclad release of claims. By signing it, Arthur Pendleton, as an individual, agreed to release, discharge, and waive any and all claims, lawsuits, or grievances against Caldwell Development Group, its affiliates, and its officers. It covered wrongful termination, age discrimination, unpaid wages, breach of contract, and anything else the lawyers could think of. I looked at the signature block. Then I looked at the definitions page. The document repeatedly referred to the employee and Arthur Pendleton. It did not mention Vanguard Land Holdings, LLC. It did not mention the property located at El Paso County Assessor's Office, Parcel 402A. Under the law, an individual cannot waive the property rights of a separate legal entity unless that entity is explicitly named as a party to the release. Vanguard Land Holdings, LLC, was a registered Colorado limited liability company in good standing. Its assets were not my personal assets. They belonged to the LLC. I let out a long, slow breath. I let my shoulders slump. I wanted them to think they had completely broken my spirit. Is there any room to negotiate on the bonus? I asked, looking down at the table. My mortgage is due next week. Can we make it $30,000? Richard smirked. He looked at Brenda, then back at me. He loved this part. He loved the feeling of holding a man's livelihood in his hands and squeezing just enough to show he could. $27,000, Richard said. That is my final offer. Sign it now, or we withdraw the severance entirely, and you can try your luck with a lawyer. I picked up the pen and signed my name on the line. Thank you, Arthur, Brenda said, taking the document and stamping it with a red stamp. We will have your personal belongings boxed up by security, or you can pack them yourself now. You have 30 minutes. I'll pack them myself, I said. I stood up and walked out of the boardroom. I went down the hall to my office. The office I had sat in for 8 years, working late nights while the cleaning crew swept the floors around me. I pulled a banker's box from the closet and began putting my things into it. My brass desk clock, a few reference manuals on Colorado water rights, a framed photo of my late father standing in front of an old surveyor's transit, and my favorite coffee mug. Ryan came down the hall and leaned against my doorframe, his hands in his pockets. He was smiling. No hard feelings, Arthur, he said. But my dad is right. We need younger, more aggressive energy to manage the construction phase. Milestone Construction is coming in hot on Monday morning, and I'm going to make sure this project runs like a Swiss watch. I'm sure you will, Ryan, I said, taping the bottom of the box. Good luck with the concrete pour on Monday. Thanks, he said, turning on his heel and walking away. I carried my banker's box out to my truck. The July heat was heavy, the gravel parking lot radiating warmth through the soles of my boots. I unlocked my truck, placed the box on the passenger seat, and sat behind the wheel. I looked at my watch. It was exactly 4:45 p.m. on Friday, July 10th. Under Section 14, of the access agreement, the temporary license for Caldwell Development Group to cross parcel 402A would terminate 72 hours after my employment ended. That meant the license would expire at exactly 4:45 p.m. on Monday, July 13th. But the construction crew from Milestone Construction was scheduled to arrive with their heavy excavators, dump trucks, and concrete mixers at 6 a.m. on Monday morning. By the time the license officially expired on Monday afternoon, they would already have 50 trucks on my land. I didn't want to wait until Monday afternoon. I wanted them to know the rules before they even started their engines. I pulled out my phone and dialed my property attorney. "Tom," I said when my attorney answered the phone. "It happened. Richard let me go. He quit my commission." Tom Jenkins had been my land use attorney for a decade. He was a dry, methodical guy who had seen every dirty trick in the real estate handbook. He didn't sound surprised. "Did you sign the severance?" Tom asked. "I did. A standard release of all claims, individual capacity only. No mention of Vanguard Land Holdings or Parcel 402A. I heard the rustle of papers over the phone line. Good. We reviewed that release draft last month. As long as Vanguard wasn't named, your property rights remain intact. Now let's talk about the timeline. Your employment was terminated at 4:45 p.m. today, Friday, July 10th. Under Section 14C of the Recorded Access Agreement, the temporary license expires 72 hours later. That puts the expiration at exactly 4:45 p.m. on Monday, July 13th. Milestone Construction is mobilizing at 6 a.m. on Monday," I said. "They have a massive foundation pour scheduled for the entire day. They'll have dozens of ready-mixed trucks coming through that entrance." "They can use the road on Monday morning," Tom said, "but at 4:45 p.m., their legal right to cross your property ceases. Any vehicle that crosses that line after 4:45 p.m. is committing civil trespass under Colorado law. I will draft the formal notice of license termination right now. I'll send it via certified mail and email to Richard Brenda and the project manager at Milestone Construction. They cannot claim they weren't warned. And I'll handle the physical enforcement," I said. On Saturday morning, I drove down to the site. The sun was hot and the air smelled of dry pine and dust. I parked my truck on the shoulder of Falcon Highway, the county road that bordered the eastern edge of the Ridgeview property. I walked over to the 40-foot strip of land. It didn't look like much. It was just a flat lane of packed gravel and weeds, running between a row of old cottonwood trees and a barbed wire fence. But it was the only gap in the shale bluff. To the left and right, the rocky ridge rose 20 feet high, steep and unstable. I stood in the middle of the gravel lane and looked at the orange surveyor stakes I had driven into the ground months ago. They marked the exact boundary of Parcel 402A. On one side of the line was the county road right-of-way. On the other side was my land. Beyond my land lay the entrance to the Ridgeview site. I pulled out my phone and called Peak Rentals, a commercial equipment company I had worked with on past projects. "Dave," I said when the manager picked up, "I need a flatbed with a knuckle-boom crane and 4 10-foot concrete Jersey barriers delivered to the intersection of Falcon Highway and the Ridgeview entrance on Monday afternoon. I want them staged on the shoulder at 4 p.m. At exactly 4:45 p.m., I want them dropped across the gravel road." "Jersey barriers?" Dave laughed. "You blocking a road, Arthur?" "I'm closing a private driveway," I said. "Make sure the crane operator is there early. I'll pay the overtime rate." "You got it, Arthur." Monday at 4:00 p.m. On Sunday night at 7 p.m., Tom sent the formal emails. He attached the recorded deed showing Vanguard Land Holdings LLC owned Parcel 402A, a copy of the signed access agreement, and the official notice of termination. The email was clear. At 4:45 p.m. on Monday, July 13th, the license to cross the property would expire and all access would be revoked. I sat on my porch, drinking a beer, watching the sunset over the Rocky Mountains. I checked my phone. No response from Richard. No response from Ryan. I knew what they were doing. They probably thought I was bluffing. Or worse, Ryan had looked at the email, didn't understand the legal terms, and tossed it aside. Richard was probably at his cabin in Aspen, convinced he had saved $1 million by firing me, and that his lawyers could handle any minor headache on Monday morning. On Monday morning at 6:00 a.m., I was parked half a mile down Falcon Highway, watching the entrance through a pair of binoculars. The site was buzzing. Milestone Construction had mobilized a fleet of heavy equipment. Excavators were digging trench lines, and a massive line of concrete mixer trucks was already forming along the shoulder of the county road. Each truck carried 10 cubic yards of wet concrete, destined for the massive warehouse slab. I saw Ryan's black Ford F-150 Raptor parked near the construction trailer. He was walking around with a clipboard pointing at things, wearing a pristine white hard hat that didn't have a single scratch on it. He looked like he was in heaven. He was the boss now. The morning passed. Dozens of trucks drove over my 40-foot strip of gravel, packing the dirt down hard, unaware that every trip was wearing down the final hours of their legal permission. At 4 p.m., the Peak Rentals flatbed truck pulled up on the shoulder of Falcon Highway. On the back of the flatbed were 4 massive, 4,000-pound concrete barriers. The driver, a burly guy named Gary, got out of the cab and walked over to my truck. "Arthur?" he asked. "That's me," I said, stepping out. "Are we ready?" "Yeah, we're ready. The knuckle boom is rigged. We can drop these things in 5 minutes. You want them right on the property line?" "Right on the line," I said, pointing to the 2 metal survey markers driven into the dirt. "Leave about a 3-foot gap on the edge for pedestrian access, but block the road completely. No vehicles get through." I looked at my watch. It was 4:35 p.m. I walked over to the edge of the gravel road. A mixer truck from Lafarge Concrete was just rumbling out of the site, its empty drum spinning slowly. The driver waved at me. I waved back. At 4:42 p.m., I saw Ryan's Raptor driving down the gravel road toward the entrance. He stopped his truck just short of the property line, rolled down his window, and looked at the Peak Rentals flatbed. "Hey!" Ryan yelled, leaning out of the window. "What the hell is this? You can't park that truck here. We have concrete deliveries coming until 6. I walked over to his truck and rested my hand on the doorframe. I looked at my watch, 4:44 p.m. "Ryan," I said, my voice calm. "Did you read the email my lawyer sent you last night?" Ryan scowled. "I don't read spam from fired employees, Arthur. Move that truck or I'm calling the sheriff." I looked at my watch again. The second hand ticked past the 12:45 p.m. "Go ahead and call the sheriff, Ryan," I said. "The license is expired. You're trespassing." I turned to Gary. "Drop the barriers." The hydraulic hiss of the knuckle boom crane was loud in the late afternoon air. With a heavy, dull thud, the first 4,000-pound concrete Jersey barrier settled into the gravel road, kicking up a small cloud of dust. Ryan stared at the barrier as if his brain couldn't process what he was seeing. Then he looked at Gary, the crane operator, who was already rigging the second barrier. "Stop!" Ryan screamed, jumping out of his Raptor, his face turning a deep, blotchy red. "Stop right now. You can't put that there. This is a public road. I'm the project manager." Gary didn't even look at him. He just pulled the levers on his control station, swinging the second massive block of concrete into place, locking it tightly against the first. "Gary's working for me, Ryan," I said, leaning against my truck, "and this isn't a public road. This is parcel 402A, owned by Vanguard Land Holdings LLC, and as of exactly 2 minutes ago, your company's license to cross it has expired." "You're crazy," Ryan shouted, stepping into my space, his clipboard shaking in his hand. "You're blocking an active concrete pour. We have 5 empty mixer trucks inside that need to get out, and 3 loaded trucks sitting on the shoulder of the highway that need to unload. Do you have any idea what happens if that concrete sits in those drums for too long?" I knew exactly what would happen. It was July in Colorado. The temperature was still in the high 80s. A concrete mixer truck carries a hot load. If wet concrete sits in a rotating drum for more than 90 minutes in this heat, it begins to hydrate and cure. If it cures inside the drum, the concrete solidifies into a solid block of stone. The truck's drum is ruined. A $150,000 piece of machinery turned into a giant, useless paperweight. The only way to fix it is to send a guy inside with a jackhammer for 3 days. Or scrap the truck entirely. I suggest you tell those 3 trucks outside to turn around and dump their loads at the plant," I said. "And the 5 trucks inside? I guess they're staying here. Or they can dump their loads on your clean grading. Either way, they aren't crossing my property." Ryan pulled out his phone, his thumbs trembling as he dialed his father. By the time the 4th barrier was dropped, sealing the road from tree line to fence line, a white El Paso County Sheriff's SUV pulled up, its yellow and blue lights flashing. Deputy Miller, a veteran deputy I had spoken with on Saturday morning, stepped out of the vehicle. "What's the problem here, gentlemen?" Deputy Miller asked, walking toward the concrete wall. Ryan ran to him like a child to a parent. "Officer, this man is blockading our construction site. He's trapping our vehicles. He's destroying millions of dollars of equipment. I want him arrested for trespassing and vandalism right now." Deputy Miller looked at me, then at the barriers. "Arthur, you did it then?" Yes, Deputy, I said, handing him a laminated manila folder. Here is the certified copy of the deed for Parcel 402A, recorded under Vanguard Land Holdings, LLC. Here is the land survey showing the boundary lines match these concrete barriers. And here is the access agreement with Caldwell Development Group, showing the license to cross expired at 4:45 p.m. today, due to my termination. Deputy Miller took the documents, put on his reading glasses, and flipped through them. He spent 3 minutes reviewing the papers while Ryan paced back and forth, swearing under his breath. Finally, the deputy closed the folder and handed it back to me. He looked at Ryan. "Son, this is a civil property dispute," Deputy Miller said. "According to these records, this man owns this 40-foot strip of land. You had a contract to cross it, and according to the contract, that right ended today. I can't arrest him for putting barriers on his own property." "But the trucks!" Ryan yelled, pointing at the Lafarge concrete mixers lined up on the highway shoulder. "They're going to lose their loads. It's costing us thousands of dollars a minute. Then you should have resolved the contract before you fired him," Deputy Miller said calmly. "If any of your trucks drive over those barriers or damage this property, I'll have to write you a citation for criminal trespass and destruction of property. Keep your vehicles on your side of the line." Just then, my phone rang. The caller ID showed Richard Caldwell's office number. I pressed answer and put it on speaker. "Arthur." Richard's voice roared through the speaker, so loud that even the deputy could hear it. "What the hell do you think you're doing? Ryan says you've blocked the road. You've got 5 mixer trucks trapped on site." "Hello, Richard," I said. "Yes, the road is closed. Section 14 se. The license expired at 4:45 p.m. "You're a dead man, Arthur," Richard screamed. "I'm calling our corporate counsel right now. We're filing an emergency injunction in the district court first thing in the morning. I will sue you for tortious interference, breach of contract, and every dime you've ever made. You're going to jail for this." "Actually, Richard, I'm standing here with Deputy Miller," I said. "He's already reviewed the deed and the contract. It's a civil matter, and as for your injunction, I'll see your lawyers in court. But in the meantime, you might want to tell your concrete drivers to start dumping their drums on your dirt. The clock is ticking." I hung up, 100 yards away inside the construction fence. The drivers of the 5 trapped mixer trucks had realized what was happening. They couldn't leave, and their drums were full of washwater and residual concrete. One by one, they began tilting their chutes and dumping gray, wet slurry onto the graded dirt near the construction trailer just to save their trucks. It was a mess that would cost $10,000 to scrape up once it dried. Bob, the veteran superintendent for Milestone Construction, walked down the gravel road toward the barriers. He looked at the concrete blocks, looked at me, and let out a long whistle. "Arthur," Bob said, leaning against the fence. "You really did it." "I had to, Bob," I said. "Richard quite my acquisition fee." Bob shook his head. "I told Richard he was playing with fire when he let you go. He thinks he can run over everyone. But we've got a contract, Arthur. Milestone is charging Caldwell $30,000 a day, standby fees for every day this site is shut down. And our contract has a liquidated damages clause for the tenant. $10,000 a day if we don't hand over the building by October 1st. "I know, Bob," I said. "I drafted that contract." Ryan was sitting in his truck now, the window rolled up, talking furiously on his phone, his face pale. "We're pulling our crews out for the day," Bob said, spitting into the dirt. "No point in paying guys to stand around and watch concrete dry on the driveway. See you at the courthouse, Arthur." "See you, Bob," I said. Gary loaded the remaining rigging onto his flatbed, and we drove away, leaving Ryan alone in his truck, parked behind a wall of concrete, watching the sun set over a silent, landlocked $65 million project. On Tuesday morning at 9 o'clock, we were in the courtroom of Judge Elizabeth Vance at the El Paso County District Court. Richard Caldwell sat at the plaintiff's table. He had brought 2 high-priced corporate litigation attorneys down from a prestigious firm in Denver. They wore matching charcoal suits and carried thick leather briefcases. Richard looked like he hadn't slept. His tie was slightly crooked, and he kept checking his watch every 30 seconds. I sat at the defense table with Tom Jenkins. I was wearing my best sport coat and a clean pair of boots. Richard's lead attorney, a man named Henderson, stood up and began his argument. He spoke for 15 minutes, his voice echoing off the wood-paneled walls. He used words like economic sabotage, bad faith, and extortion. He argued that I was holding a $65 million development project hostage over a minor personal dispute. He claimed that the concrete pour delay was causing irreparable financial harm to his client, the general contractor, and the future tenants of the Ridgeview Commerce Center. Your Honor, Henderson said, leaning dramatically on the podium, Mr. Pendleton is using a tiny, useless strip of abandoned land to choke a major economic engine for this county. We ask for an immediate emergency injunction to remove the barriers and grant my client unrestricted access to the site. Judge Vance, a sharp, gray-haired woman who had spent 20 years handling property disputes in Colorado, listened in silence. When Henderson finished, she turned her eyes to Tom. Mr. Jenkins, she said, does your client own the parcel in question? Tom stood up calmly. He didn't have a stack of law books. He just had 3 sheets of paper. Yes, Your Honor, Tom said. We have submitted the recorded warranty deed for parcel 402A, held by Vanguard Land Holdings, LLC, of which Mr. Pendleton is the sole managing member. We have also submitted the access agreement signed by the plaintiff, Richard Caldwell, in his capacity as CEO of Caldwell Development Group. Tom walked over to the clerk and handed her the documents. As you can see in Section 14 cell of the signed agreement, Tom continued, the plaintiff explicitly agreed that the license to cross Mr. Pendleton's property was temporary and conditioned entirely on Mr. Pendleton's active employment. The plaintiff chose to terminate Mr. Pendleton's employment on Friday, July 10th at 4 p.m. By the terms of the contract the plaintiff drafted and signed, the license expired 72 hours later. My client is simply exercising his constitutional right to exclude others from his private property. Judge Vance looked over the documents. She adjusted her glasses and looked down at Richard's attorneys. Mr. Henderson, Judge Vance said, her voice dry, did your client read Section 14C before signing this agreement? Henderson cleared his throat, his face flushing. Your Honor, my client was under immense pressure to close the construction loan. They believed the access road was a public right-of-way. The clause was clear, Judge Vance interrupted. This court does not exist to rescue sophisticated commercial developers from their own poor due diligence. Your client signed a contract that tied their project's only entrance to the employment status of the man they just fired. That was a business decision. Now you must live with the consequences. She banged her gavel. The motion for a temporary restraining order is denied. Court is adjourned. Richard looked like he was about to have a stroke. He stood up, knocking his chair back, and glared at me. I gave him a small, polite nod and walked out of the courtroom with Tom. By Wednesday morning, the pressure on Caldwell Development Group had reached a breaking point. Milestone Construction had issued a formal suspension of work due to site inaccessibility notice. Under their contract, Caldwell was being billed $30,000 a day in standby fees for the idle crews and equipment. Worse, the national shipping tenant we had lined up had a strict move-in deadline. If the building wasn't ready by October 1st, they had the right to terminate the lease and sue Caldwell for breach of contract. But the final blow came from the bank. The construction lender called Richard and threatened to freeze the remaining loan draws if the access dispute wasn't settled within 48 hours. A landlocked development was a toxic asset. At 2 o'clock on Wednesday afternoon, Tom's phone rang. It was Henderson. They wanted a settlement meeting. We met in the conference room of Tom's office. Richard was there, along with Henderson. Ryan was notably absent. I later found out that the bank's risk officer had refused to authorize any further discussions if Ryan was in the room. Richard looked defeated. The arrogance was gone, replaced by a gray, exhausted look. Let's get this over with, Richard said, staring at the mahogany table. We'll buy the parcel. We'll pay you $100,000. That's more than 20 times what you paid for it. It's a generous offer, Arthur. I leaned back in my chair. The price isn't $100,000, Richard. Not anymore. Then what do you want? Richard spat. Name your price. I slid a sheet of paper across the table. It was a pre-drafted settlement agreement. Here are my terms, I said. First, you will pay me the full 1.5% acquisition commission of $975,000, paid via certified bank check today. Second, Vanguard Land Holdings LLC will sell parcel 402E to Caldwell Development Group for exactly $1,200,000. Third, Ryan Caldwell will be permanently removed from any management or operational role in Caldwell Development Group, and you will provide a signed resolution from your board of directors confirming his termination. Richard slammed his fist on the table. $1.2 million for a strip of dirt, and you want me to fire my own son? You're out of your mind, Arthur. I'll fight you for 10 years before I sign that. You don't have 10 years, Richard, I said quietly. You don't even have 10 days. Milestone Construction is billing you $30,000 a day. The tenant is charging you $10,000 a day in liquidated damages. And your bank is about to default your loan. In 5 days, you'll be in bankruptcy court, and the bank will foreclose on a landlocked property that they can't sell to anyone else because I own the entrance. You sign this today, or the price goes up 50% tomorrow. Richard stared at the paper. His jaw was clenched so tight I could see the muscles pulsing. He looked at Henderson, looking for some loophole, some legal trick to save him. Henderson slowly shook his head. Richard grabbed the pen, signed his name with a jagged, angry stroke, and pushed the paper back to me. "Get out of my sight," he whispered. 10 minutes later, I walked out of the building with 2 certified checks in my pocket, totaling $2,175,000. I drove down to Falcon Highway one last time. Gary from Peak Rentals was already there with his flatbed truck, hooking up the chains to the concrete barriers. I watched him lift the heavy blocks and swing them onto the truck bed. Clearing the path to the Ridgeview site, the concrete trucks were already lined up down the highway, ready to resume the pour. Ryan's Raptor was gone. In his place was a new project manager from Milestone, a seasoned guy who actually knew how to read a blueprint. I sat in my truck, feeling the air conditioning blow cool air against my face. I was 47 years old. I had spent 20 years working in the dirt, building other people's fortunes while they took the credit. Now I was retired. I put my truck in gear, turned onto the highway, and drove home.